I am James Nedumbara, Associate Professor of Law and Executive Director for the Center for International Trade and Economic Laws at the General Global Law School. I shall be explaining the various elements of the Agreement on Subsidies and Countervailing Measures as well as the Agreement on Safeguards. Few topics in the field of international trade law have been as contentious and as complicated as the topic of subsidies. Articles 6 and 16 of the GATT 1947 were the original provisions dealing with unfair trade. The Tokyo Code on Subsidies enlarged upon the scope of disciplines on subsidies, but this was a plurilateral agreement and not all GATT contracting parties were signatories to this code. Later on in the Uruguay round, the SCM agreement was drafted and approved. The SCM agreement is a multilateral agreement. Subsidies can be disciplined either through CVD proceedings, which are domestic proceedings, or through direct challenges before the dispute settlement body of the World Trade Organization. Article 6.3 of the General Agreement stipulates that imposition of CVDs shall not be in excess of the estimated subsidy determined to be granted. The amount of CVD is to offset the distortion in the market and is not intended as any form of penalty. Like in the case of anti-dumping, CVDs can be levied only when it is demonstrated that the effect of subsidization is causing material injury to an established domestic industry. The relationship between Article 6 of the GATT and the SCM agreement is that they represent an inseparable package of rights and disciplines which must be applied in conjunction with one another. What is subsidy? According to Article 1 of the SCM agreement, a subsidy is deemed to exist if two conditions are met. The first condition is that there must be a financial contribution by the government or any public body or any form of income or price support. And secondly, a benefit must be conferred which makes the recipient better off. Article 1.1 of the SCM agreement provides a closed list of the type of financial contribution, and it includes direct transfers of funds such as grants, loans and equity infusions, potential direct transfer of funds or liabilities such as loan guarantees, then government revenue otherwise due that is forgone or not collected, then provision by government of goods or services other than general infrastructure, purchase by government of goods, and government pays to a funding mechanism or entrustment or direction to a private body. Further, it should be mentioned that the reason for providing an exhaustive list of government actions that could come within the ambit of financial contribution is to limit the kind of government actions which could fall within the scope of the SCMA. Now let us try to understand and examine the scope of financial contribution in great detail. The first thing is about the direct and potential direct transfer of funds. The transfer of funds is directly made in the case through grants, loans or equity infusion, as is identified in the main text of the SCM agreement. The word potential constitutes a financial contribution when the government promises to transfer money under certain contingencies or conditions. The SCM agreement itself has given an example of loan guarantee as a form of potential transfer. There is no financial contribution as such when a guarantee is given. Determination of this type of transfer is more difficult to identify when compared to those under the category of direct transfer. However, it must be noted that assuming the possibility that the government may transfer fund is not a sufficient reason to satisfy the term potential direct transfer of funds. The second important category of financial contribution is revenue forgone that is otherwise due. When you look at terms like tax holiday or tax credit, it actually falls within this particular category. So it is a financial contribution when the government actually forgoes something which it should have collected. The term otherwise due referred to a situation that would have prevailed had the measure in question not been implemented. Therefore, it is a matter of determining whether, in the absence of such measures, would there have been a higher tax liability. In Canada auto dispute, a dispute that came to the WTO almost a decade ago, an import duty exemption was granted to certain imported cars. This was considered to be a revenue otherwise due, as the exemption implied that the normal MFN import duty of 6% would have to be paid to the Canadian government. According to the appellate body in this dispute, this exemption amounted to revenue forgone that the Canadian government should have or would have collected. The third important category is government purchase of goods or provision of goods or services. So it actually refers to certain government purchase of goods and services with a transfer of funds to private companies. For example, in the case of Canada softwood lumber, the Canadian lumber industry was being unfairly subsidized by federal and provincial governments, as most timber in Canada is owned by the provincial government. The prices charged to harvest the timber is actually known as a stumpage fee, and it was set administratively rather than through competitive marketplace mechanism. The competitive marketplace charging was the norm in the United States, which was the neighboring market. So the US claimed that this act of setting the stumpage fee by Canada constituted an unfair subsidy within the meaning of this particular clause of the subsidies agreement. Another important category is basically payment to funding mechanisms / entrustment or direction of a private body. According to the wording of this text, the government may make a payment to a funding mechanism or can entrust or direct a private body to do so. The entrustment occurs when the government gives a certain responsibility to a private body, whereas direction refers to a situation where the government exercises authority over the private body. Therefore, both these criteria must be met in order to prove direction and entrustment. The last important category is income or price support. The SCM agreement also treats any form of income or price support as a subsidy if it confers a benefit on the recipient. The meaning of support within the meaning of Article 1.182 refers to a situation where the government directly or indirectly increases the export of any product from its territory or reduces the import of any product within its territory. The appellate body in United States softwood lumber noted that the range of government measures capable of providing subsidies is broadened by the concept of income or price support. This particular clause has been rarely used in the context of the SCM agreement, and there are very few disputes explaining the meaning of the term income or price support within the meaning of the SCM agreement. The next important point is the definition or the meaning of the term government or public body. Only when a financial contribution is provided by the government or a public body will the disciplines of the SCM agreement apply. The SCM agreement imposes disciplines on government and not private actors or private parties. If an entity is controlled by the government or the public body, then such action by that entity has to be attributed to the government in order to make it a government or a public body within the scope of the subsidies agreement. The control criterion was used by the panel in the Korea commercial vessel dispute to define the meaning of the term public body. However, the control test is not always determinative. If a private body is acting on behalf of the government and its action can be ascribed to the government, it could be considered as a public body. However, the determination of whether an agency is a public body is too controversial. Just as no two governments are exactly alike, the precise contours and characteristics of a public body are bound to differ from entity to entity, state to state, and from case to case. In the US anti-dumping AD/CVD case involving China, the appellate body noted that this issue has to be answered by conducting a proper evaluation of the core features of the entity concerned. After having considered the meaning of the term financial contribution, we have to examine the second element of the subsidy test. Article 1 of the SCM agreement identifies the practices that constitute financial contribution, but it does not define the term benefit or set out criteria for measurement of whether a benefit is conferred. Benefit encompasses certain form of advantage. According to the panel in the Canada aircraft decision, the word benefit has to be used as some kind of a comparator. This must be so, for there can be no benefit to the recipient unless the financial contribution makes the recipient better off than it would otherwise have been absent the contribution. In the view of the panel, the marketplace provides an appropriate basis for comparison in determining whether a benefit has been confirmed, because trade distorting potential of a financial contribution can be identified by determining whether the recipient has received a financial contribution on terms more favorable than that available to the recipient in the market. Article 14 of the SCM agreement provides detailed guidelines on the determination of the calculation of benefit. Accordingly, a government provision of equity capital confers a benefit where the investment decision can be regarded as inconsistent with the usual investment practice, including that regarding the provision of risk of capital to private investors in the member's territory. A loan by a government confers a benefit where there is a difference between the amount that the firm receiving the loan pays on the loan and the amount the firm would pay on a comparable commercial loan that the firm could actually obtain in the market, with the benefit equivalent to the difference between these two amounts. A loan guarantee by a government confers a benefit where there is a difference between the amount that the firm receiving the guarantee pays on that guaranteed loan and the amount that the firm would pay on a comparable commercial loan absent the government guarantee, with the benefit equivalent to the difference between the two amounts adjusted for any differences in fees. The provision of goods or services or the purchase of goods by a government confers a benefit where the provision is made for less than adequate remuneration, or the purchase is made for more than adequate remuneration, with the adequate remuneration determined in relation to prevailing market conditions for the good or service in question. Not every subsidy provided or given by a government will be subject to the discipline of the SCM agreement. Only subsidies which are specific to certain enterprises are subject to the disciplines of the SCM agreement. This means that the subsidy in question must be specific to an enterprise, industry, or a group of enterprises or industries within the jurisdiction of the authority that is granting the subsidy. However, Article 2.1 of the SCM agreement clarifies that a subsidy is specific not only when it is limited to a certain enterprise by law, which is actually de jure subsidy, but also where the subsidy is provided in fact, where it is a de facto subsidy. De jure specific subsidies are of two kinds: export subsidy and import substitution subsidies. Otherwise, de jure grounds for a finding of specificity are absent. In such a case, the other factors that may be considered in finding out whether a subsidy is given on a de facto grounds include the use of a subsidy program by a limited number of certain enterprises, predominant use by certain enterprises, grant of disproportionate or disproportionately large amounts to certain enterprises, and the manner in which discretion has been exercised by the granting authority in the decision to grant a subsidy. In considering these four factors, one should take into account the diversification of economic activities within the relevant jurisdiction as well as the length of time that a subsidy program has been in operation. The text of Article 2 of the SCM agreement requires that any determination of specificity be clearly substantiated on the basis of positive evidence. The classes of subsidies mentioned in the SCM agreement includes the prohibited category, which is called the red light category. All kinds of export subsidies and import substitution subsidies are prohibited categories of subsidies. Then it also includes the yellow light category. That includes subsidy provided by some of the national governments to certain sectors, and these sectors cause certain adverse effect. They can be challenged before the WTO or be the subject matter of a CVD investigation. Then the third category includes subsidies that are non-actionable and non-countervailable. This category of subsidies has expired now. The rationale was that if they are structured according to certain criteria, they intended to limit their potential for causing trade effect or adverse trade effect, then they should be free from other commitments. This category of subsidies expired in 1999 and have not been renewed since then. Article 3 of the SCM agreement lists subsidies that are prohibited under all circumstances. To challenge such a subsidy before the WTO dispute settlement proceeding, a complaining country need only to prove that the subsidy exists. There is no need to demonstrate that the subsidy created adverse effect on any party or on any country. The CVD action under the domestic law also may be taken against prohibited subsidies, but an affirmative injury determination is still necessary in order to make a successful challenge. The two types of subsidies which are prohibited includes, as I mentioned earlier, subsidies contingent either in law or in fact, whether solely or as one of several other conditions on export performance, which are called as export subsidies, and subsidies contingent whether solely or as one of several conditions on the use of domestic rather than imported goods, called as import substitution subsidies. The export subsidies are subsidies contingent on export performance. This includes programs included in Annex 1 of the SCM agreement. Article 4 of the SCM agreement establishes expeditious procedures for resolving disputes concerning prohibited subsidies. For this, the existence of a prohibited subsidy must be proven. If a panel or appellate body finds that the state is maintaining a prohibited subsidy, the dispute settlement body or the WTO can authorize countermeasures if the subsidy is not withdrawn expeditiously. The import substitution subsidies are also prohibited because they are either contingent on the use of domestic over imported goods. These often take the form of local content requirements, saying that a particular benefit can only be given to an industry if it uses domestic goods in preference over imported goods. It must be noted that Article 3.1b of the SCM mentions the term goods, but since local content requirements often comprises not only goods but also other cost items, the requirements themselves require a deep analysis and scrutiny. Then the next important category of subsidy includes the actionable subsidies. In essence, the use of the term actionable means that under this provision, subsidies are not prohibited outright, as they are under the categories of prohibited subsidy, but an action against the measure may be brought if it is negatively impacting trade. Article 5 of the SCM agreement sets out 3 conditions for a specific subsidy to be treated as an actionable subsidy. The one thing is injury to the domestic industry of another WTO member. So the subsidized imports are causing injury to the domestic industry in the importing country. The second adverse effect is nullification or impairment of benefits accruing directly or indirectly to other WTO members. In particular, a country may not introduce or increase a subsidy that has the effect of negating the value of tariff cut. For example, if country A reduces the tariff on certain product from 10 to 0%, it can actually negate the benefit of the subsidy by providing an equal amount of subsidy to the domestic producers. The third important category of constituting adverse effect is serious prejudice. The subsidy causes serious prejudice to the interest of the other WTO member. So in order to prove serious prejudice or on the whole adverse effect, the complaining member must demonstrate that adverse effect from certain subsidies are causing certain kind of effects. In US cotton case, a case filed by Brazil on upland cotton, the adverse effects were found to entail a price suppression in the world market for certain upland cotton as a result of the US subsidies to the domestic cotton producers. In the case of the EC large aircraft dispute, the EC subsidies to the large aircraft manufacturer, namely Boeing, were found to have adverse effect in terms of displacement of Boeing's exports to other countries, including the European market. So once subsidy and injury have been found or determined, countervailing measures can be imposed against two kinds of subsidies. One is actionable subsidy and the second is prohibited subsidy. So countervailing duty actions can be taken against both categories of subsidies. However, for a countervailing measure to be successfully imposed, a WTO member must fulfill the existence of the subsidy scheme, then a material injury to the domestic industry producing the like product in the importing country, and a causal link between the existence of the subsidy and the material injury suffered by the domestic industry. So in a way, the conduct of the CVD investigation is fairly similar to the conduct of the anti-dumping investigation, which we discussed a bit earlier. Another important thing in the conduct of a CVD investigation, or even in the case of a like product, in the case of a serious prejudice analysis, is the definition of the term like product. The like product has been defined in the subsidies agreement as a product which is identical, i.e. alike in all respects to the product under consideration. In the absence of such a product, another product which is not alike in all respects but has characteristics closely resembling the product under consideration is permitted. The identification of the like product is also important for the definition of the domestic industry. Article 16.1 of the SCM agreement defines domestic industry as domestic producers as a whole of the like product, or those of them whose collective output of the product constitutes a major proportion of the total domestic production of those products. So the definition of domestic industry is very similar to the definition of the industry under the anti-dumping agreement. Now let us come back to injury. Like in the case of anti-dumping, the investigating authority will have to establish injury in order to impose CVD duties. A determination of injury is to be based on positive evidence and involve an objective examination of both the volume of subsidized imports and the effect of the subsidized imports on prices in the domestic market for the like product. And secondly, there has to be a consequent impact of these imports on the domestic producers of such like products. The evaluation of volume requires the investigating authority to consider whether there has been significant increase in subsidized imports. This may be in absolute or relative terms. While examining the significance of volume of imports, a WTO panel in a US draft decision said there are three ways in which the investigating authority may comply with the requirements of Article 15.2 of the SCM agreement. The first is the investigating authority may consider whether there has been a significant increase in the volume of subsidized imports in absolute terms. Second, the investigating authority may consider whether there has been a significant increase in the volume of subsidized imports related to domestic production. Third, the investigating authority may consider whether there has been a significant increase in the volume of subsidized imports related to domestic consumption. Article 15.2 provides that no one or several of these factors can necessarily give decisive guidance. So examining the relative increase in the volume of import is an extremely important criterion in the volume effect analysis in every CVD investigation. Like in the case of anti-dumping, the domestic authority, the investigating authority, will have to examine the effect of the subsidized imports on the local or the domestic industry. Article 15.4 of the SCM agreement requires that the examination of the effect of subsidized imports on the domestic industry shall include an evaluation of all relevant economic factors having a bearing on the domestic industry. So like in the case of the anti-dumping agreement, it includes both economic and non-economic factors. To reiterate these elements, it includes an analysis of sales, market share, profit, productivity, return on investment, capacity utilization, factors affecting domestic prices, actual and perceivable negative effect on cash flow, inventories, employment, and such other factors. So having determined subsidy and the material injury to the domestic industry, like in the case of anti-dumping, an investigating authority will have to find whether there is a causal link between the two. So the requirement to establish a causal link is fairly similar to anti-dumping, but there is a very important requirement. If there are other factors causing injury to the domestic industry at the same time as subsidized imports, the effect of these other factors will have to be separated and isolated, and the authority should not attribute these effects to that of the dumped imports. This is actually called as a non-attribution analysis, and all the trade remedy investigations, including anti-dumping, subsidies, and safeguard investigation, include this non-attribution requirement. In addition to injury, the subsidy agreement, like in the case of the anti-dumping agreement, has included a provision on threat of injury. So in circumstances where there is no existing injury, a threat of injury can be established. The threat of injury must have occurred and cannot be based on conjecture or remote possibility. So while conducting the threat of injury analysis, the investigating authority shall consider the following factors for threat of injury. The one is the nature of subsidy and the likely trade effect, the significant rate of increase or substantial increase in imports of the subsidized imports, sufficiently freely disposable or an imminent or a substantial increase in the capacity of the exporter, indicating the likelihood of substantially increased subsidized imports, whether the imports will have a significant depressing or suppressing effect on the domestic prices and would likely increase the demand for further imports. And lastly, the domestic authority can also look into the inventories of the product being investigated. So in order to talk about the procedural aspect, like in the case of anti-dumping, an investigating authority will have to make available the important information through a gazette notification. So to reiterate the points, a countervailing duty case normally starts with the official submission of a written complaint by the domestic industry in the importing country, alleging subsidization, alleging subsidy, injurious effect on the domestic industry, and a causal link between the two. Article 11.3 of the SCM agreement imposes an obligation on the importing country authorities to review before initiation the accuracy and the adequacy of information and the evidence given by the domestic industry in their application. Under Article 11 point of the SCM agreement, the importing country authorities must determine before initiation on the basis of an examination of the degree of support either for or in opposition to the application made by the domestic producers. Then Article 13 of the SCM agreement requires the importing member to engage in consultation with the exporting WTO member prior to initiation, with the aim of clarifying the situation and arriving at a mutually agreed solution. This particular consideration is extremely relevant in the case of subsidies, where the government itself is actually giving the trade distortionary support. Then again, Article 11.9 contains an important de minimis rule that the investigation shall promptly be terminated if the amount of subsidization is less than 1% ad valorem. Similarly, prompt termination is required where the volume of subsidized imports, actual or potential, from a particular country is negligible. Then the most important, perhaps the most important issue in the CVD investigation is the calculation of subsidies. So calculating the amount of subsidy and the value of a subsidy presents complex accounting issues which cannot be fully explored in the context of this module. Once the investigating authority establishes that a subsidy is countervailable, intricate formulas are employed to determine how the subsidy be allocated over the production of the like product. In general terms, the per unit subsidy is determined by dividing the subsidy by a number of units produced in the case of domestic subsidies or exported in the case of export subsidies. The benefit or effect of the subsidy may extend beyond the amount of subsidization. So the key element is that a subsidy amount has to be established during the period of investigation, which is normally the most recent financial year. But as many subsidies are effective for a number of years, there is an obligation to allocate the subsidy amount to the period of investigation. Then the second, in the case of recurring subsidies like a tax incentive whose effects are felt immediately after granting, the total value of subsidy has to be spread over the normal depreciation period of assets. Then once the amount or subsidy for the POI has been established, the per unit amount is derived by allocating it over the appropriate denominator consisting of the volume of sales or exports of the product concerned. For export subsidies, the export volume during the POI will actually form the denominator, whereas in the case of domestic subsidies, the total sales may actually be used as the denominator. The total sales may include the domestic sales and the export sales. So the SCM agreement assumes or gives a huge amount of importance to calculating the exact amount of subsidization. The objective of calculation is to arrive at the amount of subsidy per unit of production during the investigation period. So in the case of consumer product such as television sets, the appropriate unit would be each individual item of television set or maybe one television set. If bulk products such as fertilizers or chemicals are involved, it would be appropriate to calculate the subsidy, say per ton or other appropriate unit of measurement. So therefore the simplest type of subsidy is that granted on a per unit basis. So per unit subsidy can be converted into ad valorem rate by expressing the per unit subsidy as a percentage of the average CIF, duty unpaid, unit plus import price. In this way it can be estimated whether the subsidy amount is a de minimis, since this is expressed as ad valorem. In certain situations it may also be considered to be appropriate to express CVD on an ad valorem basis. According to Article 19.2 of the SCM agreement, the members can impose CVD, countervailing duties, by matching the level of subsidy paid, or in other words, an importing country can actually impose a CVD that is equivalent to the amount of subsidization. A WTO member can impose a CVD which is sufficient to counteract the injury, but in no circumstances shall such duty be in excess of the amount of subsidy found to exist. A number of jurisdictions such as India and the European Union implement the lesser duty rule. There are also special provisions under the SCM agreement for developing countries and least developed countries. The LDCs, the least developed countries, and the Annexure 7 countries, of which India is a member, are exempted from the disciplines on prohibited subsidies. So in the case of developing countries, they are allowed to actually maintain export subsidies for at least 8 years after they acceded to the SCM agreement, or until their global market share in a product reaches 3.25% for 2 consecutive years. The least developed countries can maintain export subsidies for an indefinite period of time. In the context of anti-dumping and subsidies and countervailing measures, there is an issue of double remedies. Double remedies arise when both CVD and anti-dumping duties are imposed on the same imported product. Double remedies are likely to occur when the non-market economy methodology is used to calculate the dumping margin in an anti-dumping investigation. A number of jurisdictions impose an anti-dumping duty alongside a CVD, and therefore one could argue that there is a double imposition of duty to basically address the same situation. In United States anti-dumping CVD case involving China, the appellate body interpreted Article 19.3 of the SCM agreement, saying that there is a prohibition on the imposition of double remedies. While coming to the last agreement, which is the safeguards agreement, the anti-dumping and the SCM agreement provide remedies for counteracting the effect or the effects of unfair imports, whereas the agreement on safeguards provide remedies caused to the domestic industry on account of surge in imports. The safeguard remedies are exceptional remedies and are given only for the purpose of facilitating the domestic industry to adjust to competition. And importantly, the safeguard duties are for a short period of time. They cannot be targeted against imports from a particular country, which means that it should be applied on a global MFN basis. Furthermore, the standard of injury under the safeguards is fairly high. It is called a serious injury, which is significantly higher than material injury as required under the anti-dumping agreement and the subsidies and countervailing measures agreement. So therefore, the scope of all these agreements are different, but there is a significant amount of commonality in the nature and the methodology applied for imposition of duties. So if you look at anti-dumping, subsidies and safeguard agreement, there is a significant amount of convergence with respect to the determination of unfair practices and with respect to the determination of injury and causal link. These agreements have got different purposes, but they help the domestic industry to meet, in the case of anti-dumping and subsidies, the injurious effects of unfair dumping or subsidization, and in the case of safeguards, certain kind of temporary relief against a surge in imports causing distress to the domestic industry. Thank you.